Welcome to this presentation for Virtual Family Law Day 2020. The subject of this presentation is how to enforce a family law court order. My name's Joel. I practice law here in Colorado Springs. The goal of this presentation is for you to have a general understanding of how to enforce various types of family law court orders. I've provided several kinds of materials on the website, including a copy of this slideshow and a copy of the court instructions and forms that are referenced throughout the slideshow. Please be aware that normally when we're doing this Family Law Day in person, this is a presentation that lasts nearly an hour. What I've done is I've created a 10-minute video out of that presentation. So there's lots of detail and information missing that hopefully is made up by these materials. There are three main categories that we're going to talk about. We're going to talk about enforcement of parenting time orders specifically. We're going to talk about enforcement of money orders specifically, and then we're going to talk about the contempt process, which is a process you can use to enforce any kind of court order. So we're going to start by speaking specifically about how to enforce a parenting time order under the statute. The relevant statute for enforcing a parenting time order is Colorado Revised Statute 1410-129.5. That statute provides a wide range of remedies which are listed here. They can be anything from adding terms to parenting time to modifying parenting time, family counseling, things like that. There can be financial consequences or make up parenting time as consequences. There can be contempt remedies, which we'll talk about at the end of the slideshow, or any other creative remedies that are fashioned by the court. The one thing to know about attorney's fees under 1410-129.5 that's unique about parenting time orders is that if you bring this kind of motion and you are successful, you are entitled to attorney's fees. It's not just discretionary by the court. The court can't choose whether to award you attorney's fees or not. The court has to award you attorney's fees if you've incurred attorney's fees. That may make a difference in terms of how you decide whether to hire an attorney or not for a motion like this. The relevant forms are 1418I, 1418, and 1419, which, as I mentioned, are included with the materials to this presentation. Next, we're going to talk about everybody's favorite subject, money, how to enforce orders regarding property, maintenance, and child support. Regarding a property transfer, there's Colorado Rule of Procedure 70. And the purpose of this rule is to allow parties to complete legal transfers when the other party isn't cooperating. So if you've been awarded a car or a house and the other party won't sign the legal document giving you title to that car or that house, then the clerk will sign it for that party and the transfer will be complete. Attorney's fees are available under this rule but not mandatory. The relevant forms are listed here: JDF 1800, JDF 1814, and JDF 1815. It's important to read 1800 carefully because 1800 gives the overall instructions for collection of money issues in enforcement of court orders. Regarding an income assignment, so the relevant statute is 1414-111.5. The purpose of this one is to collect future streams of income. So if you're owed money going forward, child support or spousal maintenance, and you're concerned that it's not being paid or it hasn't been paid in the past, this will make sure it gets paid into the future. Again, you want to look at Form 1800 for general instructions. For this one, you want to look very carefully at Form 1801. That provides specific instructions on collecting an income assignment and filing for one. There is a separate form for a notice of income assignment. It's a federal form. That form is included with the materials. And then there's also JDF 1805 and 1809. 1809 is if there's a health insurance issue. And just to be clear, you want to make sure you're reading 1801 very carefully. If you have an old support order, one that's entered before about 1996, the forms might be different. The law changed several times, and so make sure to read JDF 1801 extremely carefully before making any filings with the court. The last money issue, other than contempt, that we're going to talk about is entering a support judgment. So whereas an income assignment looks forward as to getting your future streams of income, a support judgment looks backwards and looks at money that you are owed. So the purpose is to collect arrears. The relevant form for that is 1813. Essentially, you just need to calculate the amount you're owed. It can then be entered as a judgment of the court. Once it's entered as a judgment, you can take standard collection action. So you might want to hire a collection attorney at that point. You can do things like garnish a bank account, put a lien on somebody's home, things like that, to make sure that you're able to collect that judgment. Now, this is the reason most people attend this presentation, which is to understand a little bit more about contempt. So this portion of the presentation will talk about punitive and remedial contempt, and we'll talk specifically about the process. And then we're going to end just by asking a few questions about whether you need to hire an attorney or not. So the relevant rule for contempt is Rule 107. The relevant forms are JDF 1816 and 1817. The process for filing contempt is that you file the motion and the proposed order. The court, if it believes the other person is guilty of contempt or could be guilty of contempt, there's going to be an advisement hearing. That advisement hearing is a chance for the court to advise the person accused of their rights. If the case is still not resolved, then there's going to be a trial. That's a trial to the bench, so it's a trial to a judge, not to a jury. And the thing to know is contempt can be pursued in conjunction with or in addition to other remedies. You just can't double up on getting the same remedy twice, so you can't get a windfall because the other person isn't complying with the order. There are two kinds of contempt. There's remedial contempt and punitive contempt. Remedial contempt is the problem-solving side. So what's it going to take to remedy this problem? The important thing to remember is that if there's a specific thing that you want from the court, you must ask for it in your written filing. And that's a notice issue. The other party and the court have to be on notice of what you're asking for. You cannot just show up at the trial and say, oh, it turns out I actually want this thing that I've never asked for before. That's a notice problem. The court isn't going to be allowed to grant you that. So make sure you think carefully about what you want before you file that motion, because you're pretty much stuck with what you write down there. Jail and fines are available, but they're not available as punishment. They're only available as remedies. So somebody can be incarcerated until they comply, but they can't be sentenced to a jail term. The elements of contempt that must be proven are that there is a valid order, the party knew of that order, the party had the ability to comply with that order, and the party did not comply with that order. The other side of the contempt coin is punitive contempt. So that is punishment. So jail and fines are available, and they're available as sentences. So somebody can be sentenced to a term, say a month or 3 months, in jail for failing to comply with a court order. And the purpose of that is to vindicate the dignity and authority of the court when somebody thumbs their nose at the court and says, I know what I'm supposed to do, and I don't want to do it. I'm not doing it. I'm choosing not to do it. So the elements that must be proven beyond a reasonable doubt. The party who's accused of contempt is entitled to an attorney. And those elements are the same as the elements in remedial contempt, as you can see on this slide, but there's an extra element, which is that the violation was willful. It was on purpose. And that's really what punitive contempt is about. It's about vindicating the dignity and authority of the court to somebody who's refusing to comply on purpose. The last question I often get asked is, do I need a lawyer? The answer, of course, that any lawyer will give you to any question is, it depends. Some simple answers: have you been accused of punitive contempt? If so, you need a lawyer because you could be facing fines or jail time. And if you're facing a punitive contempt charge and you cannot afford an attorney will be appointed for you. In all other situations, you want to think globally about whether you need an attorney, whether it's cost effective to hire an attorney. So how much money is at stake? Are you going to pay more to an attorney to fight something than you are to get out of the process? Are you working well enough with the other person to negotiate a resolution that meets everybody's needs well enough? Are attorney's fees available? In most contempt remedies and in most enforcement remedies, attorney's fees may be available. And remember, in enforcement of parenting time orders, they're actually mandatory. So that may tip you one way or the other in terms of whether you're going to hire an attorney. How comfortable are you with the instructions that have been provided? How comfortable are you in the courtroom? What a lot of people do want to do is they want a consultation with an attorney. So you may want to call around town and find an attorney who will give you a consultation, who you can speak to about your options and determine whether you do or do not want an attorney. That's all I have for you today. Thank you for attending this virtual presentation. Thank you for attending Virtual Family Law Day. We really hope to see everybody next year in person, and we wish you the best of luck with your matter going forward.